As you've no doubt heard, the U.S. Supreme Court is currently considering one of its most significant cases on abortion in decades. Posed as a direct challenge to Roe v. Wade, Dobbs v. Jackson Women's Health Organization calls on the court to overturn Roe and return the question of abortion to the people. The court should decide the case by early this summer. With so much at stake, many are talking about Roe. But how many of us really know what Roe means? Consider this. While 2/3 of the American public say they support Roe v. Wade, only 18% agree with what Roe actually does, which is to effectively legalize abortion for any reason through all 9 months of pregnancy. Roe is far more extreme than most people realize. Together with its companion case, Doe v. Bolton, Roe eliminated many state laws and made it virtually impossible for people to protect the lives of women and their unborn children from the violence of abortion anywhere in the country. And it did so even though the U.S. Constitution is completely silent about abortion. With the Constitution set aside, the court invented a standard called viability, which the court is currently reconsidering in Dobbs. But what is viability? When Roe was decided, a baby was viable, able to live outside the womb at 24 to 28 weeks. Yet advances in medical technology have since allowed countless babies to survive outside the womb at 22 weeks, with some even surviving at 21 weeks. Doe v. Bolton, another case decided on the same day, made it even more difficult to protect the lives of unborn babies and their mothers. In combination with Roe, Doe essentially authorized abortion at any time for any reason. In 1992, the court had a chance to correct itself in Planned Parenthood v. Casey, but that ruling only made things worse. It added yet another arbitrary standard called undue burden, which has created confusion, frustrated both sides, and continued to leave unborn children vulnerable to an abortion regime that has ended the lives of 60 million babies and counting. It wasn't just what the court decided in Roe that's so problematic. It's also how it decided the matter. Roe put a stop to a conversation we need to have about abortion itself. Even legal scholars who support abortion agree that Roe was poorly decided. The late Supreme Court Justice Ruth Bader Ginsburg, for example, one of the most well-known abortion advocates during her long career, criticized Roe as heavy-handed judicial intervention that halted a political process, prolonged divisiveness, and deferred stable settlement of the issue of abortion. Likewise, prominent Harvard constitutional scholar Lawrence Tribe has written extensively about Roe's fundamental errors, while the late John Hart Ely, who taught at Yale, Harvard, and Stanford law schools, said that Roe is bad constitutional law, or rather, it is not constitutional law, and gives almost no sense of an obligation to try to be. Edward Lazarus, who served as a law clerk to Roe's author, Justice Harry Blackmun, agrees. He said that, as a matter of constitutional interpretation and judicial method, Roe borders on the indefensible. Roe was not the first time a Supreme Court decision was terribly wrong and led to horrific human rights violations. The court was wrong in 1857 when it decided in Dred Scott that a slave was not a person. And it was wrong in 1973 when it decided the same thing about a baby in the womb. The Constitution does not guarantee a mother's ability to take her child's life. Our government should protect life, not sanction killing innocent human life in the womb. Enough is enough. It's time for the court to correct its past mistakes and allow for laws that protect all innocent lives. Follow this case at adflegal.org and find more videos like this at adflegal.org/Freedom Matters. You can also check out this channel on YouTube and follow ADF on Facebook today.